Were the State Department cables connected with the national defense? Of course they were, simply by the virtue of the fact that they were classified. Were they obtained in violation of the Espionage Act? Again, trust me, don't have time to get into it. Bradley Manning was not authorized to copy 250,000 State Department cables, much less turn them over to WikiLeaks. Should Assange have known that the cables were obtained in violation of the Act? I find it very difficult to believe that a jury, particularly an American jury, would find otherwise. Assange had to have known that Manning was not entitled to take these cables from the US government and was not entitled to turn them over to WikiLeaks. There's a reason why these sites are anonymous. So, that's a very problematic provision for Assange. The next one I want to talk about is 18 USC section 793E. This was the provision at issue in the APAC case, in the Israel case. 5 requirements are particularly important here. First, again, we see any document related to the national defense. It says related to instead of connected with. That really makes no difference. We are once again dealing with the misuse of classified documents. And again, all of the cables in WikiLeaks obtained are classified. Second, Section 793E prohibits, quote, communicating, delivering, or transmitting a classified document. And now, notice what we don't see here. We don't see the word publication. A number of scholars have argued that Section 793E's failure to specifically mention publication indicates that this particular provision doesn't apply to the media. I think that's unfortunately excessively literal. I very much doubt that a court would say, because it doesn't say publication, media organizations are per se excluded from the ambit of this particular provision. I find that very unlikely. And, if you're reading ahead, in any case, the provision expressly criminalizes acts that are short of publication. Even the mere retention of a classified document qualifies as espionage, as long as the government has been polite and asked for you to return it. And in the WikiLeaks case, the United States government has, on a number of occasions, asked WikiLeaks to turn all of the documents that it had obtained and all copies back to the US government. So, the criminalization of retention, obviously a major problem for Assange. The fourth element, if the classified document is released, instead of simply retained, it has to be released to someone, quote, not entitled to receive it. That is also a fairly vague concept, and the defendant in the US versus Morrison case that I mentioned earlier also challenged the any person not entitled to receive it language as being so vague as to violate due process. That challenge was no more successful than the other vagueness challenge. The Fourth Circuit held that any textual vagueness in the requirement was cured by the United States government's classification system. In other words, as long as a classified document was given to somebody who did not have authorization to look at that document, by definition, that person was not authorized to receive the classified document. So, again, a very low standard. Now, getting a little more interesting. Willfully. This is the mens rea requirement, and it's really the key to this provision of the Espionage Act. According to the APAC case, the one major precedent we have in this area, the government must prove 2 things to establish that the defendant willfully communicated or retained a document relating to the national defense. First, it has to prove that the defendant knew that the document was classified, and second, it has to prove that the defendant knew that he was not entitled to receive it, or if he gave the document to somebody else, knew that that person wasn't entitled to receive the classified document. And again, that's it. Very minimal mens rea requirement, and most importantly, as this quote from the APAC case indicates, the defendant's motive for retaining the classified document or for giving the classified document to somebody else is completely irrelevant to his criminal culpability. That's obviously a very significant problem for Assange. He did not have to intend to harm the United States by releasing the documents, and the media gets this wrong all the time, and many scholars get this wrong all the time. He did not have to intend to harm the United States to violate this provision. He simply had to know that the documents were classified and that WikiLeaks had no right to look at a classified document. That's it. It is an incredibly minimal mens rea, and is precisely the absence of any intent to harm requirement in this particular provision that has led at least one scholar to describe the provision as, quote, pretty much one of the scariest statutes around. And I think we can agree with that assessment. Now, the final provision that I want to discuss, 18 U.S.C. 794A. It criminalizes transmitting national defense information to a foreign government. This would be the government's preferred provision for one simple reason. That one, if you can imagine. In fact, the government considered charging the APAC defendants with a Section 794A violation precisely because it had the death penalty as an available punishment. Now, has Assange violated this provision? Well, we have a few major elements. Once again, we're dealing with classified documents. In terms of the mens rea, we have with intent or reason to believe that it is to be used to the injury of the United States or to the advantage of a foreign nation. Now, think back to the first provision that we looked at. The first provision required the defendant to know or have reason to believe that the classified document in question had been obtained in violation of the Espionage Act. This provision is a little different. It requires the prosecution to prove that either the defendant intended to harm the United States or that he had reason to believe that the release of the document would harm the United States. And again, that is a very, very low standard. All the government has to prove is that Assange should have known that releasing these documents might advantage a foreign government or injure the United States to satisfy the mens rea requirement. Now, you might be skeptical that releasing the cables would actually harm the United States or advantage a foreign government. I would certainly agree with that position, but again, I seriously doubt that an American jury would, especially given that these documents are classified and by definition are supposed to harm national security, agree that this release was so harmless that this provision couldn't be violated. Now, there is an additional requirement here. The provision also requires the defendant to, quote, communicate, deliver, or transmit the classified document to a foreign government. This is perhaps the most perplexing requirement in this section. There is no question that WikiLeaks has communicated, delivered, or transmitted the WikiLeaks cables, but has it communicated, transmitted, or delivered them to any foreign government? And there are two interrelated issues here. The first is whether the government would be required to prove that one of the State Department cables had actually been received by a foreign government. Did they actually have to look at one of these documents and obtain the documents? If that is an element of the crime, if the prosecution would have to prove actual receipt by a foreign government, that could be problematic, unless the United States has some way of kind of knowing exactly who has accessed these cables. I'm not a computer expert, I have no idea. But if they have to prove that, that could be problematic from a prosecution standpoint. But, unfortunately, it is far from clear that proof of receipt is actually required by this section. The communicates to any foreign government language in Section 794A is functionally equivalent to the language in the most serious charge against Bradley Manning in his court-martial. Article 104 of the Uniform Code of Military Justice, which is an aiding the enemy charge. Article 104, the aiding the enemy charge against Bradley Manning, makes very clear that aiding the enemy, at least, doesn't require actual receipt, and you can see the bolded language there. If actual receipt is also not required by Section 794, which I think is pretty likely given the parallel between this particular provision and the provision in question, then it would be enough for WikiLeaks to communicate with a foreign government when it released the State Department cables. You wouldn't actually have to prove receipt, you would just have to prove communication. Now, you might wonder, I hope you do, how did WikiLeaks do that? How did it communicate with a foreign government by releasing the cables? Certainly no evidence that they put these things on the net in order for North Korea to read them. So how did they communicate with a foreign government? The answer comes from the directly or indirectly language. The US government's argument would almost certainly be that WikiLeaks communicated indirectly with a foreign government simply by publishing the cables on the internet, where it had to have known that any foreign government could in fact access them. Now, that may seem like a bizarre idea to you, that you can communicate with a foreign government simply by starting a website, putting up a classified document. I hope that seems like a bizarre idea to you. But again, another charge against Bradley Manning indicates that this will absolutely, almost without question, be the United States government's argument. Here is a different allegation against Bradley Manning in a provision that is also somewhat structurally parallel to Section 794. Did he wrongfully and willfully cause it to be published on the internet, knowing that it would be accessible to the enemy? Now, here's where it gets really interesting. I think so. The drafters of the manual, I hate this expression, the drafters of the Manual for Courts Martial, which is the official guide to how the US government holds courts martial, they appear to have recognized that newspapers might be guilty of communicating with the enemy simply by publishing information on the internet. Here's the sample specification in the Manual for Courts Martial. Notice the final bolded clause here. Indirectly communicating with the enemy via a newspaper is only criminal if the communication was intended to reach the enemy. Not simply enough to put it up there knowing that it's possible that a foreign government or the enemy could obtain it, but it actually, in terms of a newspaper, has to intend for it to be reached by the enemy, and by kind of analogy, a foreign government. Now, if the same limitation applies to Section 794A, that would be very good news for Julian Assange. There is really no evidence that WikiLeaks published these cables intending a foreign government to access them. Now, is this restriction imported into Section 794A? I have absolutely no idea. We'd have to wait for a prosecution to see whether a court would say that in the context of a media organization, like a newspaper, like a WikiLeaks, indirect communication to the foreign government has to be intentional. I don't know. What I do know is that it is very disturbing that the US government appears completely ready to argue that a media organization can in fact communicate with a foreign government merely by publishing documents on the internet. By that logic, of course, directly related to you, any academic, any blogger who posts a State Department cable knowing that it was classified is also guilty of espionage, because that person has indirectly communicated with a foreign government and could conceivably be punished with death. Okay. Too far. So, that's the legal analysis side. I think we can safely say that Assange could be successfully prosecuted for espionage if in fact such a prosecution was ever brought. So let me turn to my second question. Should Assange be prosecuted for espionage? I think by now you know my basic answer to that question, which is certainly an absolutely no. There is, however, I think, a more interesting version of that question, which is this. If Assange is ever prosecuted in an American court for espionage, is there any convincing legal or normative rationale for not prosecuting WikiLeaks media partners as well? The New York Times, Le Monde, Der Spiegel, The Guardian, etc. Is there any convincing reason why it should just be Assange and not the media partners? Now, from a legal perspective, I think the answer is clearly no. I don't have time to run through the entire analysis, but there is little question that the newspapers have also violated the Espionage Act by publishing the cables. So, they obtained the same classified documents as WikiLeaks, and under the Espionage Act, it makes no difference that the media partners got the cables from WikiLeaks, whereas WikiLeaks got the cables from Bradley Manning. There has no legal function, no legal difference whatsoever. Like WikiLeaks, the newspapers knew full well that these cables were classified and that they had been illegally obtained by whoever obtained them.